There are some snacks just in this little annex room right here as well, so you don't have to go all the way downstairs or go all the way upstairs. Alan just walked out. Just a quick introduction for Alan. Alan graduated with a Bachelor of Science degree from Syracuse University in 1974. He has his Juris Doctorate from Gonzaga University Law School in 1977. He is He was Chief Assistant County Counsel for Washington County, Oregon, prior to becoming Assistant Attorney General for the state of Utah. First chair-elect of the Environmental Law School of the Oregon State Bar. He's currently serving as counsel to the Utah Division of Facilities, Construction, and Management, which oversees state construction, real estate leasing, operations, and maintenance. He is also Section Chief for State Agency Counsel. Drafted key documents and provided legal services for almost $4 million in state of Utah construction projects, including the construction of the facilities for the 2002 Winter Olympic Games. Also assigned to the Division of Purchasing and General Services Capital Preservation Board, and my personal favorite, the Prison Rehabilitation. Alan has been a presenter at numerous seminars, including those for Lorman Procurement Association's state bar meetings in Oregon, and the author of the Value-Based RFP Procurement System chapter of the Construction Business Handbook, Aspen Publishers, 2004. Thank you. Way out.
Thank you, Ed. It's a fantastic interview. I thought when they announced this seminar of contracts and procurement, I think they probably should have mentioned the ethics and penalties part, because I think a lot of that's been in the news lately with our office, and I think that there are a lot of security laws out there and traps for the unwary, and they're traps not only for our office, but traps for our clients. And so we really need to start honing in on this, because Utah is getting bigger and bigger. Eventually we're going to be doubling in population again in the next 20, 30 years. And we're going to have to be more like these other bigger states where they really do enforce a lot of these laws. Many we have on our books, many people aren't aware of it. So I'll try to go through this. Some parts I'm going to go through quicker than others because you can get a hold of the PowerPoint on the internet. Usually I try to come up with humorous presentations. There's no way to talk about bribery statutes and put a bunch of jokes in there. And I actually had something I found I took them out of the PowerPoint. So if you came here for some good jokes and some good laughs, you're probably in the wrong line. And you can see everybody else left with the one that probably has the jokes and the laughs. So there are many laws that actually apply besides the procurement code penalties. When we talk about the procurement code, all of our agencies get involved in procuring some things. And even in our office, I mean, even if you hire an expert witness, a law firm, you go to Kinko's to make copies, you're getting involved in procurement. And these penalties and gift provisions that I'm going to go through, right now, they apply to virtually all of us. But what most people aren't aware of is we also have bribery statutes, Utah Ethics Act, Health Officers and Employees Ethics Act, the Antitrust Act, which few people really know anything about, that deals with anti-competitive practices, and then Procurement Code Part 23, which is brand new in Senate Bill 190 of the 2013 session. Bottom line is, if you walk away with anything here, is, in fact, I think you end up giving me a score after this presentation. So, if I were to give all this to one of you, all these candidates, I would hope it wouldn't affect your score. Maybe it would. But that's what this is really all about. Is don't take anything. If you're involved in a selection committee, and the next person you interview sees that the last one just gave you all these candies and everything in a hat, and it says, ABC law firm on it. Well, don't interview the next time you wear your ABC law firm hat or something like that. Things get you.
Here's one for you.
Oh, okay.
Across
Go
the
ahead.
street, right, and I assume we're gonna be informal today with this big crowd.
Come on, Randy, come on up.
Across the street, at the south town, whatever they call it, the convention center.
Yeah.
Today is an event happening called the Engineers Conference.
Okay.
And all the engineers,
Remember, we're on camera.
all the engineers, well, this is a real problem that I've dealt with over the years. All of the engineers, some are state employees, some work for cities, some work for counties, some work for contractors, and some work for the engineering firms, are over there meeting this week to discuss government's construction projects relating to highways. And every breakout session has a little refreshment thing out there. And as you go to every refreshment room, it says, this refreshment room is sponsored by XYZ Construction Company. And this refreshment room is sponsored by Joe Blow Construction Company. Where does that end?
Not good. It's good for them to have,
mean,
those
it's
companies,
not targeted to
you can take
individuals.
things from the association, as we'll get into this later, because the association's not gonna be a vendor. For instance, UDOT does not hire the actual association, which has all sorts of competitors belonging to it. That association does not submit a proposal or a bid, but members of the association do. The problem with that is, why do they have that names up there? Because that member wants to make sure that that procurement officer from UDOT knows that that particular item is coming from them. And why do they want them to know that particular item?
Everybody has it, and all they're getting is a Coke.
Yeah.
And,
Yeah.
you know, are you gonna waste your career over a Coke? And it's not just to the individual, I mean, it's not just to state employees, it's to employees of their competitors.
Well, if you look at the papers in the last year about our office, you think if anybody said, well, everybody does it to anything that's been talked about there, that would work with the public? I don't think so. I think the public is really tired of, quite frankly, public officials are also tired of being viewed this way, of thinking that we're on the take. You know, and there's that public perception, and we have to break through that public perception, and we have to set the example. And I'll give you an example, you know, this is not a great example, but, you know, I was talking to, unfortunately in my faith, we have no missionaries, so I'm not trying to missionary beat that. I was talking to a rabbi friend of mine in Arizona, we were talking about Sabbath.
Moses wasn't a missionary.
Well, he did have a book and a badge and a bicycle. But I was talking to a rabbi friend in Arizona, and we talked about the Sabbath, and you know how the rabbi has to do all these things. And the rabbi said, well, you know, if I don't do all these things, what are my congregation going to do? They're going to do half of what I do. So if I shop on the Sabbath, then they're going to shop and do other things too. So we're in the AG's office. You know, if we're taking these things, what are our clients going to do? You know, and so we really have to set the example. And as it turns out, as I go through this, you'll find out that we're now dealing with crimes. This is from the National Association of State Procurement Officials, officers. They say don't take anything. You know, I'm not going to go through this part in detail because I want to get into the other things. The other thing you don't want to ever be involved with is an antitrust case. So if you have a client or yourself, you're continually hiring the same attorney over and over again, same court reporter over and over again, your clients continually having the same people hired an architect over and over again to design their buildings or whatever it is. Sooner or later, you might get a call from Jim Palmer of our Office of Commercial Enforcement or somebody else there that deals with antitrust laws. And you really don't want to do that because not only is there trouble damages, and any person can bring a lawsuit for that, but there's also fines and imprisonment. And when you take gifts, that's just one of the things that a prosecutor looks at to see that you have a special relationship. with the entity that keeps on getting the contract over and over again. And that perhaps you're creating a monopoly for a particular service. And these antitrust investigations are actually pretty ugly. We had one some years ago that got pretty public about architects and in the specification of hardware. There was a concern that they were actually getting the specifications of hardware from the hardware manufacturers. And so if you're an architect and you're getting your specification for hardware from a particular manufacturer, guess whose hardware is likely to get purchased through that contract? That hardware manufacturer that gave you the specs. And so our office launched an investigation, antitrust on that. There were architects that had to hire attorneys and spend time dealing with defending themselves. I had one come to my office basically in tears. Their life was not fun after that investigation began. We did finally resolve it through a settlement working with the local chapter of the American Institute of Architects. But the point I'm trying to make is you don't want to be involved in one of these. It's a really ugly scenario for everybody. Then these statutes, almost nobody talks about these, the bribery statutes. Sooner or later, somebody's going to look this one up. I wouldn't be surprised if the investigators dealing with our office right now are probably looking at all these statutes that I'm sharing with you today. You know, that it's, you're talking about second and third degree felonies. Well, what is it? Is it a candy bar? Is it $10? Is it $50? Is it $1,000? You know, they talk about if it's less than $1,000, it's a third degree felony. But it doesn't say, there's nothing there for whether it's $10 or $20. So, once again, we have to be careful there.
So is the $50 now out?
The $50 is in the Ethics Act. But that's why I'm bringing this up, because the Ethics Act doesn't override the bribery statutes. The bribery statutes don't say, however, you can take $50. Okay, Ethics Act, for the ethics portion says, yeah, if you're an employee, and by the way, a non-procurement employee, you're not involved in the procurement process in any way. The procurement process is more strict than the Ethics Act. It's okay. But assuming you're just thinking of the Ethics Act with that $50, you still can't take anything in the bribery statutes if it's to influence you.
Yeah.
So if a reasonable person is going to think that you're going to be influenced by it, you know, they might start inferring if this intent. I mean, who knows? All I'm saying is once one of these things start against you, you're in trouble. Bill?
Hustling, and then Herbert did the same thing. They have an executive order that says you can't take anything.
That's right. And I attached that, it's in the file on the AG website for this presentation. I put that into the proclamation, though I put my PowerPoint. But that's a very good point. There's also an executive order, which theoretically includes our office, certainly includes our clients. You know, and so you're correct.
So
What I'm trying to say is, don't rely on the Ethics Act and that $50.
would one way to deal with the engineering conference to take copies of the bribery statute over to some education sponsors?
You could. Yeah, we actually do, and I work with Jim Palmer a lot in commercial enforcement. He finds out about some of these conferences and actually calls them and helps put a stop to some of the things they do. You know, most of them are very good people. You know, they're just thinking this is a courtesy and being kind, and they're actually donating to the function and whatnot. But we're really starting to take some serious prosecutorial efforts in this area. I think our office and others, and so I wouldn't rely on the past where, well, this has been done this way for years, so I think we're okay.
So for advising the private sector, though, then their option would be to donate the money to the association and be listed as a general sponsor of the event and not do this specific.
Exactly right. I think if the association said, you know, here's our donors and listed like 50 competitors, and then you go and you have, you know, donuts, a hat, whatever, you know, as long as you don't go over that Ethics Act amount or your procurement amount, you know, that's okay. Because you don't really know who gave that to you. You know, so I think that is, so then when you're involved in the selection process, you can't really say, well, I gave it to ABC engineering firm. You know, somebody accused you, you gave it to them because they gave you all these goodies at the conference. You can say, I didn't know that they gave you those goodies. I thought maybe the competitor who lost it, because they were there too. Official misconduct. I'd like to see more enforcement on this because this happens to us, and it's really hard to prove, and it's something that isn't covered by the press well enough. And I won't talk about who does it to us. You'll have to think about it on your own. But sometimes when you do your job right, somebody calls you, some other public official out of our office, they want you to do something for them. It's actually a crime, a Class B misdemeanor. If somebody tries to benefit themselves, and I'm going to go on further with this, there's no slide related to it. It's called intimidation, that we'll get to later. But the bottom line is you should be doing your job as is, and other people should not be trying to get you to do something that goes against the law in order to benefit themselves.
How far, I'm trying to think how far this question, I'll just give you the example. My client, let a contract tested, but the contract is in place. Part of the issue was creating a lot of perception.
Does this microphone work?
Yes.
I should review the mic. It does.
Yeah.
It's supposed to.
I-
Press
I-
it till it goes green.
Okay, can I turn it on? Okay, yeah.
It's-
Okay, there we go, try that. So very good.
Well, I guess my question is just how far, we have a circumstance in which we have, my client has led a contract. It was contested, there was a lot of stuff involved, finally getting the contract in place. The contractor, part of the expectation we had of the contractor was trying to repair some of the issues that we have. The contractor wanted to have lunch and invite many of the other community partners in. And my client said, what should I do? And I said, well, if you go to lunch, pay for it yourself. And I guess I'm wondering, that's not an anticipation of procurement. Procurement is completed, but it will, it has renewals and stuff like that. I think you should sort of comment on that a little bit, to extend that.
Well, I'm going to get into some slides later that talk about even socializing with vendors is something you should really avoid unless it's part of business. A lot of times it really does have to be part of business. You have a long meeting with a vendor, or we hire an outside counsel for something, and you meet with them for 8 hours, you have to have lunch in the middle of it, right? But you just don't have that buy you the lunch.
That's what
You
I
know,
thought.
now, what you could do is have them put the lunch in the bill to the office. It's okay for the office to pay for the lunch, or the client. You know, it's part of the business meeting. And that's what I advise my clients, is that when I advise the division of facilities, if they do if I have a project manager doing a construction project in Cedar City, or in St. George, and they're gonna meet with a contractor for lunch, put it on the tab. It's part of the project cost. You know, but don't have the contractor pay for your lunch. This is what I was leaving at here. The other section I was talking about is when you do something unlawfully that you're supposed to do, but here is, and the key word here, I think that can come up as intimidation. When somebody tries to get you or your client to do something that isn't necessarily following the law there. Not supposed to be doing this. I got a call from an agency the other day, I won't mention the name of the agency. I'm not saying this happened in this instance, but I can see where it could. They got an appropriation from the legislature in the bill of bills. And I'd like to hopefully have a meeting with John Fellowsby or somebody to see what can be done about this. But sometimes in the bill of bills at the very end, there'll be an amount of money that goes to an agency, there'll be nothing written about what it's for. Well, what does the agency do with the money? All of a sudden, somebody calls them and says, hey, guess what, it's for me. That was for me. Then you gotta dig around and find out, well, what did the legislature do, or a legislator or somebody? How did it get in there? I think that type of scenario where you have these, I'm gonna call them boxcar appropriations, can lead to eventually where somebody feels a little intimidated when they're in an agency and they're not even, attorneys like us, some of these people work in agencies, they've been there for several years, they're young, and somebody calls them up who's an intimidating type figure and says, hey, that was allocated for me. What if it was? What if it wasn't? Could we be dealing with this over here? And it's a class B misdemeanor. Hardly ever see this enforced, but I think sooner or later, we're gonna see this law enforced.
We had a classic example of that with, you guys all know that I know all the specifics of all these. I know which bodies are all buried. And some of them only half buried.
That's Randy Hunter for the video.
We had a classic example of the federal legislation where this happened. And so you can't blame anybody in the state. Out of the blue, UDOT gets told that they're building a new ferry across Lake Powell. We have one ferry already, and it's never full. And so all of a sudden, we get a federal appropriation to build a second ferry across Lake Powell. And we had no idea it was coming. It would just pop out of the blue, and we were given money and told to build a ferry. Okay, we had to build it. We built it. For those of you who don't know, UDOT owns the ferry across Lake Powell.
Did not know that.
We now own two of them. Because somebody thought we needed the second. Nobody knows where or how that came about.
Right. And was it in a bill that said ferry boat right next to it? And that's what we're supposed to do with it?
It did down the ways, if you read it real hard, you realize that money that was appropriated was for a ferry boat across Lake Powell.
Well, I'm
It
sure,
took us a good 6 months to figure that out.
I'm sure the legislators, investigators will be listening to all the tapes of these
So
proceedings.
this was not a state matter, this was a federal matter. It's just interesting how, a good example of how those boxcar bills sometimes have things that the agency didn't see, and no one knows where it came from or how it came about, and it's out of Congress, so it's state laws don't apply.
Yeah, and I'm not saying this happens, but let's say that just in theory, just to talk about it in theory, if somebody's on an appropriations committee for an agency and deals with the agency's funding, and that person who's on the appropriations committee were to call the agency and say, hey, this is what it's for, a lot of agency people, they're gonna be a little worried about telling that person something that they don't wanna hear. Like, oh, sorry, we can't use it for that purpose. Why? Because they don't want their budget affected. I see this even with my agency on a different level with DFC, on Division of Facilities Construction and Management. There's Mike Carter, who represents SUU and Dixie State University. I mean, even on that level where even my client can be involved in discussing with the building board about who gets various monies, sometimes these universities and other agencies, they feel a little intimidated to sometimes tell my client what they really think about things, how the process of running or this or that, because they never want to say anything that might affect their appropriation. The same thing happens with the agencies and the legislature. They know these various things, but sooner or later, I think somebody is going to get in trouble on this one, where somebody does go too far and threatens either somebody with their budget or threatens an officer. But you saw the slide before where the public servant also has to be careful not to do things that violate the law.
So how does that apply to members of the state house?
I didn't see any exceptions in these statutes for misconduct or interference with public servants. I didn't see anything, any legislative type exception on these crimes, or in the bribery statutes for that matter.
So they threaten to interfere with your budget in a particular area if you don't do something
It's, yeah, but it's a tough one because, you know, let's say legislators should be involved in policy, and they might say, well, why would I give a whole bunch of UDOT money if UDOT doesn't do things that are good for the public? And I'm suggesting things that are good for the public. So you have to distinguish between that and them really trying to get UDOT to do something that's really not legal
Particular developer.
or to benefit themselves, or their friends or their family. I think those things are going to make a difference. So I think there is some gray area there, and I think it's the extreme cases that are probably going to get prosecuted, you know, on that. But I think the ones where, you know, a politician can say, well, I did tell UDOT I wasn't going to support their budget because I felt that they aren't going to do these things, and then I'd rather give that money to another agency that does things that helps the public. So they might say that, but I don't know. It depends on the particular case. As officials, we have to be careful about not misusing the public monies. This is a felony in the 3rd degree. Depending on, once again, there's a smaller print here. It's different degrees of crimes depending on the amounts. So the whole point I was getting at before, I haven't gotten to the procurement code yet, and those penalties for taking gifts. I'm just trying to let everybody know there's a whole lot of other laws here, and it's so complicated that if you're going to advise your clients, tell them really don't take anything that's any value. Well, does that mean you can't get a holiday card? Well, you're going to put the holiday card on eBay. I doubt it. Okay, so the holiday card probably doesn't really have any market value. Or you ate a peanut. Okay, you're probably not going to be the first person prosecuted under these laws because you ate a peanut. But if you had a prime rib dinner, maybe. The Ethics Act. You think the Ethics Act would be one of the clearest laws we're going to go through, but it's actually one of the most unclear laws. Question in the back.
I had just a really quick question. This is something we've run into a couple of times, and I'm curious what your thoughts are. So we have to sometimes take depositions of the witnesses, like the expert witnesses and things like that, for people on the other side of our cases. And we'll do it at the offices of the attorneys on the other side. And they're always private attorneys, and they're often very well-off attorneys. And sometimes they'll say things like, if it's all day, they'll be like, oh, well, we're ordering lunch anyway. You know, we're ordering it for us, we're ordering it for our experts. What the heck? You can just eat lunch with us. And we have struggled with that. I mean, is that an okay thing to eat lunch with them?
Well, the firm that would be seeking business with the Attorney General's office, or the
No.
firm just on the other side?
They're always on the other side.
Well, they're not a vendor. Then you gotta worry about the Ethics Act. It doesn't sound like it's a bribe, or is it?
Well,
Are you going to give a little light on the questions because they took you to Lakai? If they took you to Lakai, probably go over the Ethics Act amount of $50.
Think Jimmy John's. They're ordering sandwiches from Jimmy John's. It's not a big deal.
Yeah.
It's something I'd actually rather not eat.
Yeah. So I mean, you have to use some discretion on that, but many law firms do apply to the Attorney General's office for business. So you have to be careful about it on that end if you're involved in selecting them or recommending them. So Mike, you have a question?
I'm just stricken by a bit of the irony in that question, since one floor below us we're hearing about civility. That sounds a lot like civility to me, as opposed to what we're talking about. So just some of the de minimis aspects of this are just hard to wrestle with because we know they're there. I don't suppose, unless it's an aspiring political prosecutor in some outlying county who has nothing to do but prosecute somebody for taking a $10 or something, there's going to be a real de minimis consideration here, it seems to me, by a prosecutor to say, well, the $10,000 one I want in the headline. The $30 one I want nothing to do with. And somebody's going to make a judgment call. And then over here, that sounds like it's a gesture of civility a lot more than it is anything more. And all of these different things seem to have a train wreck when we start trying to dissect them as findings. It's kind of crazy.
It is. I had a attorney working with me on a case. I don't want to get too specific. specific, but, but I was involved in selecting him, and I knew we were probably gonna have an overrun on this contract, and I would have to be reviewing whether to give him more money or not. And when we were discussing the case at his office, just as I was going to his office, actually, to discuss the case, I should say, there's a chicken place right by there. So let me buy a chicken sandwich. They're unbelievable there. It's gonna be like $3 or $4. I said, no, you can't buy it for me. He said, I can't buy you a chicken sandwich? I said, yeah, believe it or not, it's now a crime. After May 1st, 2013, under the procurement code, I'm going to be involved in, was involved in selecting you. I'm going to be involved now in maybe approving some additional funds for you. So, you can put the chicken sandwich on the tab and build the steak, but you can't buy it. And he looked a little befuddled, but at the same time, I think there's a little respect there too. That no, I'm sorry, you can't buy me lunch. I ended up buying him lunch. And even out of my own pocket, and get reimbursed for it. I mean, how many times in public positions do we do that? Use our own pens or papers, computers, things ourselves that, we put in our own money to do these jobs. Most of us are not here to make a whole lot of money off of the public. There's better jobs for that. So why get the bad press or the bad image for it? But there are differences. Like, let's say you have a deposition with an attorney, and the other side of the attorney says, well, I want all the depositions to be held on my yacht in Hawaii, and I'll pay for you to come to Hawaii, and you can ask the questions of my client there. Well, that case doesn't go very well, and you didn't do a very good job in the deposition. One of your bosses is going to think, well, are you sure you asked really good questions while you were on their yacht in Hawaii that they paid for? Did that somehow influence your ability to really go after what you needed to do and go against them? That's one extreme. The other extreme is the simple thing. They said, here's some toast that we have in our office to hold you over while during the deposition. She grabbed a piece of toast. I thought you'd be prosecuted for that. But if you go on their boat, you can get some free goodies. That was pretty bad. Would you agree with that? I mean, there's an extreme.
I realize that this operates across the spectrum. But Andy's question about the $50, question in the back about the lunch, fall somewhere on that spectrum. In some places the line gets darker, but I maintain with some of the students that I interact with, study water, to study black and white, it's just to study a different shade of gray. That's essentially what we're talking about.
Well, it's a lot of gray in the ethics act. Look, an occasional, not pecuniary gift. What's occasional? It says you can take an occasional. Not pecuniary means that they're not giving you cash. But what's occasional? Can they give it to you every week? Hey, it's Monday. That's the occasion. We're celebrating every Monday. It's occasional 3 times, 5 times a year. It's not really clear, is it? It'd be interesting to see a prosecution on this. I guess somebody's going to get prosecuted if they take it every day or something. But if they took it 3 or 4 times, I think it's going to be a tough prosecution. And there's some exceptions. So the Ethics Act, ironically, is one of the weaker statutes that we're going to be reviewing. The bribery statutes were stronger. The antitrust laws are stronger. When we get to the procurement code, that is stronger.
It's probably not our line of purpose.
Yeah. And frankly, I think $50, the one extreme, when we get to the procurement code, the Ethics Act does have criminal penalties. And it could even void the transaction. When we get to the procurement code, the old one's really strict, and you can argue that the new one's too strict as well. At the same time, the Ethics Act's too loose. For instance, if you're at a counter at Doppel, you represent Doppel. I mean, should your person at Doppel who's reviewing somebody's permit get 4 gifts of $49? I don't think so. That person says, well, it's occasional, but it added up to about $196, worth of watches or whatever. The public finds that out, that somebody got a permit and gave that to that person occasionally because they did it once a month or 4 months. That's not a good thing. Ethics Act, I think, is too loose. Somebody can make an argument that the procurement code is too tight. Certainly the old procurement code is too tight. This is before May 1st, 2013. that was given to you was a felony. It was a felony to give it. Here it was a felony to offer it. It's a felony to accept it. That was the law since like about 1981. And actually, I don't even know anybody prosecuted under it. Maybe it was so strict that it got ignored. I don't know. Kent Beard likes to use this slide. He's the chief procurement officer. I would agree with him on all this because I think some things here don't have any market value. But the fact that he thought it means other people can think it too under the old law. That if you got a pen or a coffee cup or a paper clip, anything. Because under this, it was only to offer anything. Any emolument, gratuity, contribution alone. And we have a load of this, whether it's given for the person's own use or for the organization. Sir, you're a procurement officer for the University of Utah, and one of your vendors decides to give the University of Utah $1 million. You think that's ever happened? I bet it's happened a lot. Under the old law, you can almost read that and think that that was illegal. That was a felony for them to give it to the organization because they're a vendor of the University of Utah. Well, Office Depot, virtually every business around was probably a vendor of the University of Utah. So this was sort of a really draconian law that we had around for a long time. So we tried to change that in Senate Bill 190. We actually still made it a little too tight, in my opinion, last year. So I'll tell you what happened with it. That's why I got this caution here. So I'm going to go through what we're proposing for this next legislative session, which just being cautiously optimistic, I think will pass. When we revised these statutes here that were so strict into Senate Bill 190, we created a $10 limit for gratuities, certain things. But we all even excluded lunches, so we can't take lunch at anybody. But that applied to everybody involved in procurement, and that's the law today. And the special districts, and other people said, you know what, we don't want to be part of it. We think your law is still too tight. So an exemption clause was put to Senate Bill 190 for these special districts. Ironically, I'm speaking to you this afternoon about the procurement code. Kirk Torgerson wasn't too happy about that. I wasn't too happy about it because we represent the whole state. It'd be nice to have everybody on the same page in terms of what you can pay and what these crimes are. So we began to have a series of meetings with the Special Districts Association, representatives, higher ed, public ed, the League of Cities and Counties, the League of Cities and Towns, the Association of Counties. We met numerous times over the summer, and we came up with a consensus document that I'm going to go through here, which is being sent to Robert Reese and Legislative Council as we speak. And this is likely to be closer to the law you're going to see at this session, which is why I'm going to train a little bit about it, because we're very optimistic because it's such a broad-based consensus for this change in the procurement code requirement, where before it was, you couldn't take nothing. May 1st, it was up to $10 under complicated circumstances, and now a new set of provisions. Yeah.
I'm thinking, you talked about history of this law, and just to extend and breadth some of these things. I'm thinking about the scenario that is probably quite familiar to many people. The scenario that I have in mind is not hypothetical in any sense. I'm thinking about, shall we say, the dawning, if you will, of the age of computer, and the gesture made by Apple to give computers to all the schools in the state, which was readily accepted because they had no budget to buy computers, and they knew that this was the thing to come, and that if kids weren't computer literate, they would be very far behind their peers on other states or wherever. They accepted gifts of computers. Ultimately, that was not done on a request for proposal or anything. We
Right.
put it in a positive light for our discussion. It's like, we're the only one giving these away. Are you interested? And everybody says yes. We get grade schools everywhere in the state, or almost everywhere, I'm sure, that wind up with Macintosh computers on the table for free. And you look at that from the public policy and the legislature, everybody else can say, great, we couldn't have done it any other way. A year from now, they need an upgrade. It will only cost this much money. And or it needs this certain software package, it will only cost this much money. And the next thing you know, Apple's doing a pretty brisk business with the state based upon the fact that they gave these computers and no one bats an eye because we wouldn't have been able to afford it any other way. This all suggests that this was, we should have a penitentiary full of school administrators for all this felonious conduct. And I expect that there will be a public outcry to the contrary when that's the case. It's really difficult to get the balance on this thing.
I think we had about 1,000 prisoners around 1980. Now we have about 8,000 state prisoners. So that's it's gone up about 7 or 8 times since 1980. If that happened in the next 30 years, well, maybe a lot of those people might end up in there. Because, there could be antitrust issues with that. But we're going to go through that. You can see there's some provisions here to discuss donations. So hang on to your question. Let's go through the donation section. Because we try to enhance the ability to have donations to public institutions. Thanks. Maybe the mic will help here. So that was a good question. There's definitions at the beginning of the new Part 23, active period of procurement. What we did is, and unfortunately it's not necessarily in order, but you have to follow these guidelines of statute writing, I guess, where they always put the definitions in the front, that you can't always stick them in where you really want them. But what we did is, the current law, active right now since May 1st, says if you're involved in procurement, you participated, you're on a selection committee, you're in the Attorney General's office, you're making purchases, you're hiring expert witnesses, whatever, you can't take any hospitality items over $10 in value. And I believe there's a limit of over $50 a year from any one particular entity. And it excludes lunches, by the way. So a lunch, you just can't take it all. Cash, you cannot take it all. But if it's really a hospitality item, like a donut, you're in the attorney's office and they give you a donut, fine. Unless that donut is somehow worth $11. Okay, and there are very few $11 donuts running around. But if there are, we'll certainly try to find out. So what we did is, in the new law that's being proposed, that Rob Reese is working on right now, and Senator Jenkins appears to be responsible for, we decided to break up, when we met with the special districts in the cities, towns, everybody was concerned about this. $10 is so strict for everybody. And a lot of them have commissioners who are used to the Ethics Act, they're used to this $50 number. So we broke it down into 2 categories: procurement professionals and procurement participants. A procurement professional is somebody like Ken Beers, the chief procurement officer for the state, and his staff. They're all procurement professionals. UDOT, they have procurement professionals on staff. Division of Facilities Construction Management, they have procurement professionals on staff. AG's office, certainly somebody like Werner, would be a procurement professional for us. But some of us that just do a little bit here and there, we're going to be called procurement participants, and we're going to be bound by things when we're involved during the active period of procurement, when we're actually involved in the procurement activity. And then for that, this $50 rule is going to apply. It's not $10. It's $50 for participants, but $10 for professionals. That was basically the agreement we worked out with all these public entities, and hopefully the legislature will enact it. There's definition of gratuities in here. Let's talk about what a gratuity doesn't include. So, like I said, the best default position is to take nothing, and that's to advise your clients that, because we went through the bribery statutes, the antitrust statutes, and whatnot. This is so complicated that that's the best default thing, unless it's something that like I said, a donut or something like a card or something with no market value. But to be clear, we wanted to make sure certain things were off the hook. Because remember, I showed you the old statute back here that existed for 30 years that says it was a felony to offer anything. You know, it didn't even say it had to be over $1 in value. So in the new proposed law, we're trying to make it clear what it doesn't include. It doesn't include items included in a contract or grant for the performance of it. See, you hired a contractor and for UDOT, and as part of the contract, you're supposed to give UDOT tires or something. Well, fine, take the tires. It's part of the contract. Maybe the contract says that they're supposed to train your people at lunches 4 times a year, and you're paying for it as part of the contract. Well, now you go to those lunches, the contractor's providing the lunches and the training seminars, fine, it's part of the contract. So, make it clear in the contract or in the grant what those requirements are, what they're supposed to do for you, and if you're just taking things that they're supposed to give you, and it's part of the contract, you're covered. Items requested the property evaluate the reward. Sometimes you need samples. Sky miles, if we have an airlines contract with somebody. Meals in association with a training seminar, including the contracted grant. That actually could be part of the first little loan right there. But we talked about this earlier, meals provided by an organization that does not respond to procurements. So if the Association of General Contractors calls Jim Soper and says, Jim, gather up all your procurement officials, we want to have a special lunch and talk about issues we have with you guys. Well, can they take those lunches? Well, I guess as long as it doesn't go over the Ethics Act limit, and as long as it's not a bribe or intimidation or some other crime, yeah, they can do it, because why? Because the Association of General Contractors, they don't submit bids to UDOT to do roads. They have competitors that belong to the organization that does that, but they don't do it themselves. We talk about product samples. This gets a little complicated here, that product samples aren't really supposed to be for the individual person themselves. They're supposed to be for the agencies. And this is bound to pass. Political campaign contributions. It looks like vendors can make political campaign contributions. They want that. Well, we can laugh about it, but you know, we talked a little bit about the press that our office has gotten the last year, which is, you know, been sort of a painful year. But when we met with the special districts, and there's 400 special districts, many of them in rural areas, and there's some little cities, and we met with legal cities and towns, they said, do you know how hard it is to get in some of these little places somebody to agree to be a public official with all the laws that apply to them? We already have the Ethics Act, we have this and that. Please don't make it any harder for them. We can't get really good citizens to even take these jobs. So we put in the exception for political campaign contributions. And that's part of the reason why we distinguish between procurement professionals and procurement participants. And I'll get more into that in a little bit. Hospitality gifts, she said, does not include a meal. That's important to know for later. Kickbacks and bribes, we did things similar to that. I want to get to this procurement professional part. Because we wanted to make sure that procurement professionals, these are the people that can't take anything over $10, but they also can't take meals or other specified gratuities that are exempted from that $10. Once again, to make sure that people would decide to be a mayor of a small city or on their city council or a leader of a special district, you're not a procurement professional if you hold any elected office. You're a member of a governing body, you're a chief executive, chief assistant, superintendent of a school district, principal, vice president of a college or university. I mean, imagine how difficult that would be. What if presidents of colleges or universities do a lot? They go around asking people for money, right? They want to make them procurement professionals. How would they be able to fund their campuses? I mean, then we even exempted out these really small entities. If a public entity is an annual budget of $1 million or less, or has less than 4 full-time employees, they're going to be procurement participants. In other words, they're only going to be held to the rule, and it's going to be $50 for them when they're actually involved in an actual procurement. A procurement professional, though, is 24/7 on their restrictions for taking gifts. But as you can see, many people are exempted out of it. I once had a sentence in here, but they tossed it out. I said, well, maybe everybody in the rules should indicate who the procurement professionals are, so you can just look at the list and just know. But they took it out, but you can still do that. You could enact a rule or something that indicates, or a policy for your agency saying these people, like here's the Attorney General's office, Warner, Tiffany, you know, so-and-so and so-and-so, there are procurement professionals. Everybody else is a procurement participant and is only held to this when they actually do hire a court reporter or somebody and actually get involved in procurement. But it's not really your job, like Mike, it's not your job or it's not my job to be just hiring people. It's a major component of our job. We're not procurement officers, really.
So say you're on a board that approves contracts, and the agency director brings you the list of consent items and you consent to them. Which are you?
If you're full-time on that board, you might be a procurement professional, because not, that's a major part of your job. If not, you're a participant. The difference is, the professional can't take anything over $10. The participant can't take anything over $50. But if you're in the AG's office, try not to take anything. So as I said, we've got the bribery statutes, we've got the intimidation statutes that we went through, we've got the antitrust statutes, and we have to set the example for the clients. And so whatever you take, the clients are going to think they can take double. Because you're the attorney. I mean, you're the role model. Jim? I'm sorry, Randy.
I've got a question about what constitutes procurement professionals.
Okay.
In UDOT, you've got the people who prepare the plans and specifications, and they advertise for the bids. And they sit on committees that reviews the bids and accepts the bids and awards the contracts. Then they take that contract and pass it over to another group that oversees construction. And for every little contract out there, there's probably 15 people on this team that oversee that contract. Inspectors. They inspect everything that drives and how it's placed. They have nothing to do with the bid, the award of the bid. But they score the performance of that. And the performance of that project is considered in future bids. Are these inspectors procurement professionals?
Yeah, I think UDOT is going to have a lot of procurement professionals because UDOT is mostly a procurement type entity.
Yeah.
And so you don't think it's on? Oh, you know what, the red light went on. And so what I think that means is that the battery is dying. But you have to speak closer to it. But UDOT has a lot of procurement professionals on it. And if they're doing that a lot of the time, I would tell them, look, don't take anything over $10 and don't take meals. Act like you're a professional. So when in doubt, I would say the best advice is to defer to the professional category. And why should they be taking $30 or $40 worth of stuff anyway if they're involved in making selections?
Well, they don't do that. Every week, in fact, in most projects, every morning, there is a meeting in the morning of all the players. And they say, well, this is what we're going to do today. This is what we accomplished yesterday. This is what we did not accomplish yesterday. Is there coffee at that morning meeting? You know there's coffee at that morning meeting.
Coffee's okay.
And
for professionals or participants. But you're saying coffee,
maybe there's a
coffee provided by who? Is it provided by the vendor?
Yes. I mean, these meetings happen in the offices of the contract.
Okay.
And they're required by the contract to have these meetings.
And those evaluations.
Well, as we just said before, there's an exception for things that are included in your contract or required by your contract.
So if they're required to have a meeting, they have a major meeting once a week and a daily briefing every morning, and there's coffee there, is that considered required by the
Yeah,
It's
I mean,
required by the
you're
contract.
paying for it. I mean, the contractor,
The coffee
Supposedly, when they bid on the project, they knew they had to get through those meetings and provide the refreshments and everything. That's supposedly in that contract price.
The refreshments aren't called out in the contract.
No.
It's usually not a line item. You know, I mean, maybe you not should have the refreshments there, but in any event, coffee's okay. I mean, this is a pro-coffee bill. And the reason why I say that is because when we get further in here, there's even if you're a procurement professional, you can still take hospitality gifts up to $10,
So
even if they declare to be a professional.
one Starbucks per person.
But that's limited by $50 a year, isn't it?
Yeah.
So that coffee pot's on in the office.
So you're not guilty if the total value of the hospitality gift is less than $10. So once again, it has to be $11 cup of coffee.
Or two.
There's no Starbucks allowed.
But honestly, I really think the first prosecution of this is probably not going to happen because somebody has an $11 cup of coffee. You know, even if it has some special goodies in it. You know, it's probably going to be something much worse than this. But nevertheless, your clients do need to be aware of it because there are criminal penalties for it. Notice for the participant, if they're not a professional, they're like the Ethics Act, except that the occasional $50 gift is now capped at $50 per active period of procurement. So if they're involved in the procurement process, you just can't take more than $50 from that vendor. Now, should they take anything? Really, it's not a good idea. You know, and if you have ABC Construction going to UDOT, as I said, on the selection committee, and they appear before your selection committee, and they go there and they see their competitor X, Y, and Z, and everybody in the selection committee is wearing X, Y, Z shirts and hats, and all the logos from them and their calendars there, and then X, Y, Z gets the job, what does ABC think? ABC, who didn't get the job, thinks, wow, I guess my competitors gave them shirts and everything, just below $50 in value, but boy, they're really close to them. No wonder why they got the job. I'm going to file a protest. Then what happens when they file a protest? Okay, your procurement is now on hold. Okay, while they try to look at why you were biased against them and biased towards the other side. And so you have to think about what kind of appearance does it have here when you accept all these goodies by one end. The issue of donations or contributions was brought up by Mike, I believe. It's not, you're not guilty of these sections for giving, offering, or promising a donation or contribution to a public entity unless it's given with the intent to get the award. So, yeah, you can, if you're at the University of Utah, you can receive $2 million from, let's talk about some of the big contractors around that build at the university, Layton Construction, Big D, Jacobs Construction, you know, like Oakland, you know, many of these, you know, they're good people. They make a lot of money probably doing projects, and they probably donate to our universities to enhance our state, and that's just great. Okay, what's bad though is if somebody from any firm, I'm not saying any of it, but anybody in those firms will do it, but let's say some firm comes here and does it, says to you, look, I'm giving you $1 million to the university. By the way, you know I'm giving you that $1 million because I really want that hospital expansion project, and I expect you guys to treat me right when I apply for that. Okay, well that's not exempted here in the donation requirements because that was done with the intent to induce them. And you're not guilty for receiving it as long as that intent's not there. This can happen the other way around. Let's say you're a school district. You call up Office Depot, and you say, you know, our school district's not doing well. We really could use your $1 million contribution this year. And Office Depot says, I don't know. You know, we're having a hard year. And the school district says, well, you want that extension on that contract, don't you? I mean, we better see that donation. Well, that's not an allowable donation, and that person who did that for that school district, whatever public entity is, now just violated the law. Okay, you can't tie your donations to your procurements. But we tried to open it up above here where, yeah, you can get donations to public entities, just don't link them to your procurement processes. You almost have to wall it off. And if you're a big entity, it's easier, like the University of Utah, hopefully you have a procurement section and you keep that separate from your people who call in people for donations. The worst thing that could happen is if their donation section calls the procurement section and says, hey, here's a list of everybody donated this year, keep this in mind as you start procuring products. That would be bad. And there's criminal penalties. The old law was just a felony of any value. Now, 1,000 or more, second degree felony, 250 or more, third degree, 100 or more, class A misdemeanor, less than $100, class B misdemeanor. Another thing you need to know, somebody got in trouble with the state. This room was more full because the interesting thing is that a lot of, and I should say a lot of people, there are some people who, in government around the country, and some even in our state, who end up losing their jobs because of violating these kind of laws. Small purchases, lumping them together, giving it all to one person, especially if they're related to you or something like that. Bad idea, isn't it? This makes it a criminal offense to artificially divide small purchases. So you can't take $1 million contract, and let's say your small purchase limit is $10,000. You can't give $9,000 over and over again to the same person for something and call it a small purchase.
I'm walking through this, it brings back a lot of the issues that have come up in my office. A lot of the changes that you're describing, I find myself very inclined to agree with, but it leads me to wonder, in some respects, I'm listening to your point of reference and not doing so to be overly critical, but you keep referring to big construction projects, big contractors, and even the University of Utah, the biggest thing in the state. Whereas juxtaposed to that, you've made reference to small towns and small districts and places where you have a hard time getting people to even exercise their citizenship.
Right.
And I appreciate the effort that's been made to take a 30,000-foot look and a 15-foot look at this based upon the demographics to which it will apply. But your point a minute ago, hopefully the fundraising arm will call the procurement arm and say X, Y, Z. In my environment, that's not going to happen in that sense. It's going to happen because these people work elbow to elbow with each other, and it's just going to be common knowledge.
Are the same person?
They're not necessarily that same
Yeah,
person.
let's go back to the donation
But,
section.
but that's not going to happen as an affirmative gesture. It's going to happen as an environmental reality. And I'm not, the balance is far better, but I'm still a little uncomfortable with the things that intersect by their nature. And I don't know if that's ever going to be something that can be well divided or well articulated.
Let's look at the bribery statutes, okay?
No.
Forget about the
Your
procurement
point
code.
on
Bribery
that is,
statutes
well,
have been there.
this is the best effort I've seen in a long time for everybody to try and fold X statute in with Y statute instead of just do it with binders on and write something independent of all other statutes and think that it's done what needed to be done. I think that the draftsmanship on this and the attempt to take references from all corners of the law and try and create something that's well reconciled, I applaud the effort. I'm seeing something here that I haven't seen in such a long time.
Go ahead,
This kind of
repeat
thing.
something. Hope we're getting this on the tape here. I didn't know you were going to say such good stuff. I've been giving advice for a long time ago.
No, really,
So Mike is talking about what a great effort this was.
No, I think, with all due respect.
Yeah.
With all due respect,
We're getting to the best part.
this stuff gets dealt with from a Salt Lake perspective all the time. It gets dealt with a big city perspective all the time. I mean, Randy probably sees this in some similar respect that I do because he's got DOT as a amalgamated huge entity up here, and he's got district offices of 4 people in Panguitch, all of which have to be equally affected by this law. And
Now, the guys
in this state, that hasn't seemed to work out in any other way other than the Salt Lake perspective. And I'm only trying
You're
to speak
right.
honestly to what my experience has been.
You're right, and that's why I thought those meetings over the summer were a good wake-up call. When we met with the League of Cities and Towns, they weren't there just representing Salt Lake City and Provo and Ogden. They were there also representing a bunch of little cities and towns. And when the Special Districts Association was meeting with us at all those meetings, by the way, they're actually going through these sections that I'm going through with you now, this Part 23. They're doing it, I think, this morning at their meeting, then I'm supposed to meet them this afternoon at their conference. There's about 400 special districts in the state, and many of them are really small, and sometimes they'll procure one thing in 5 years. You know, maybe they're gonna build a new sewer plant, but after they build that sewer plant, they're not gonna build another one for maybe another 30 years, or who knows? You know, and then there's a couple of people on that board and whatnot, and they're in a small rural area of Utah around all their friends and vendors, and they have a hard time with all this, and just trying to be good, ordinary people. And when we met with them over the summer, we realized we had to start tweaking these laws so that we didn't criminalize good people. And I'm worried that we still do it in some extent on these donations or contributions. If you're the University of Utah, it's pretty easy to create this wall. I think you're the donation department or procurement department, because you're a huge university, and one might be located in one building and one could be located in another building. But what if you're now a little district, a mosquito district, or somebody that somehow does go out for donations? How do you separate that, you know, knowledge from then going and giving your procurements? And what you do, it is a little more difficult. Hopefully, prosecutors will keep that in mind.
In many ways.
Because even this
it's entirely
thing,
intractable.
yeah, it's going to be really difficult. Did you have a comment?
A couple, one
I
was
can't
just-
see your name through your badge,
Oh,
but.
I'm with the contractor.
Oh, Valerie, okay.
Yes, a couple of things came to mind. One is within the special districts too, because if there's ever a good place for crime and embezzlement, it's in the districts, because nobody even knows most of them exist. And you've got
I'm glad I didn't
everything.
get the mic for that. Because they really take offense at that.
You've got little districts, you know, that are like the South Iron County mosquito district, and you've got the CUP that's dealing with millions and millions of dollars. So they need to not be treated the same. But the other thing that hit me was the division. I was wondering, because at the federal level, as a small contractor, we're always asking the feds to break up their procurements into smaller pieces so that small businesses can handle them and can get bonding instead of aggregating. And I'm wondering if that was done into a problem like that.
Well, with the state,
Because we want
If-
things to be smaller so that we can.
yeah, if you're continually buying a particular item, then you better, you should look at your rules for your small purchase threshold, whatever it is. Like, let's say, we're allowed to, at the Attorney General's office to, and I haven't gotten to this part, I don't even know if I'll be able to get to it this morning, our own Attorney General rule on procurement, which you should read, is provided on the website. Then you should take a look at that. But we can acquire, as the Attorney General's office, professional services under a small purchase under $100,000. So let's say you're in the criminal section of the Attorney General's office or litigation, you want to hire a firm, and it's $90,000. You can do it as a small purchase, okay, for a particular case. But if you know, in fact, that you're going to lump 5 cases together and you're going to be giving them $500,000, you better issue a request for proposal, something along those lines, because it's really not a small purchase. Now you're really giving them $500,000 for the legal services, and they're all connected. Now, this gets a little tricky. They really are genuine different things. It just happens to repeat here and there. You should be fine. But if you know right now that you really want them to do 5 cases together for $500,000, okay, don't artificially divide it into 5 $99,000 chance. Because they'll look at it and somebody will use that as an excuse, frankly, to get rid of somebody under this. And I don't have to mention names, but if you look at the papers for the last few years, I guess there was somebody involved with small purchases that lost their job with the state.
Alan, can I take a minute for an example there? I don't even dominate the discussion, but we just fired a coach a year ago because he had a vendor that had donated a bunch of stuff. I mean, we're right back into context.
He's talking about a coach who hired a vendor?
We had a coach who had a vendor who donated a bunch of stuff, period. But this coach had said he wanted to thank that vendor by sending more business his way. Classic, right down the line with contract. And in order to do that, he broke up a purchase of equipment into small purchases so that he thought he could go on the radar with this. Didn't work. And by the time it was over with, he lost his job for making that attempt. So the temptation is out there from the donation standpoint and the procurement standpoint. Once again, it may not be the same individual as it was here, but in some of the lesser populated contexts, you're going to get that without even looking for it.
By the way, I wrote this in the proposed statute, being required to return the value. I'd like to see that done more often instead of some of these other things. You know, make the person have to pay back, you know, what they should have been taking. To the public entity.
Who called that one out, Mike?
I think it became evident to somebody else that all this equipment was being bought from one vendor, whereas in the past that hadn't been the case. And somebody finally started to add 2 and 2 and 3 and 3 and realized that this was a you scratch my back, I'll scratch yours kind of situation. And then when it was looked at more closely, it was found to be so. And under the circumstances, once again, you've got a coach, a high-profile individual, very appearance of propriety in the preface of the whole discussion, and on the basis of the position that person held, not only as an institutional employee, but beyond that, we're talking about the coach of young people who's a role model, an example, and everything else to which you've alluded here. All that can be in the ultimate decision that there was no way that this judge would be allowed to be retained in the position as a person was like that.
Yeah, and athletics this comes up a lot. Now, I made a mistake here because this is what we're proposing to be voidable. I have to tell you that the current statute in Part 23 of the procurement code that's in the packet on the website, the contract's void. That's what it says today. So if somebody involved in the contract took over $10 worth of value of something that they shouldn't, violated this part, the contract is void. Not even voidable, no choice. And it doesn't talk about who can void it. A member of the public, I guess, could file a case and say, I want this contract declared void. I approve that this public official took $15 from this particular contractor. So we've rewritten this, especially with the help of some bond counsels, that's where you see the word bond in here places, to say, no, it's voidable, and it's only the public entity that can declare it voidable if some of these violations that have occurred. So this is what we're proposing as a new law. I'm actually supposed to sit down with Senator Jenkins next week when I talk it through with him. This is one of the points I'm going to bring up is that we really need this new law. We can't afford to have a $1 billion UDOT contract be declared void because somebody got a meal. You know, but that's almost how the current law reads. And that would be somewhat ridiculous. But if this new law goes through, we could declare it voidable. And there's sometimes we may want to. I mean, if you hired, if you're UDOT and you want an honest opinion from an engineer, you know, in your department, and reviewing a road, is it safe or not? And they did a contract, and you found out that engineer got all sorts of goodies, you might want to avoid that contract, because you really wanted it to be more objective. But it will be the public entity's choice under the new proposed language.
Would they be able to capriciously void it? I mean, say there was a $15 or a $65.
Capriciously void it?
A
Well, I think
$65
there's,
but the contract itself
I think
is in the public.
I think there's general law that it generally, as a government official, you can't do anything that's arbitrary or capricious.
Right, but I mean,
So,
would that be?
there would be due process rights that would probably get involved, so probably not. It would probably be difficult to, even under the current law, avoid $1 billion contract because of a $15 meal, let's say, but nevertheless, that's the letter of what's written there. And so, it's not worth getting into that, but that's why we need to change that language to voidable, which is our proposal right there. I want to get on socialization. The National Association of State Procurement Officials has rules about that. Basically, if you, let's say your brother or sister works at Jones Waldo, we're just throwing them out. I think they're great firms. But we're deciding whether to hire them. And you get called into the front office of the Attorney General and say, well, should we hire Jones Waldo? I think at that point, you better say, well, you know, my brother works there. And in fact, my brother will even be making some money to get that contract. So, you know, maybe you ought to talk to somebody else in the office about whether you want to hire Jones Waldo. So it's not per se illegal to socialize with vendors because there's some constitutional limits on that. Like you should be able to have Thanksgiving with your brother or things like that. But if you are really close to somebody who's dealing with our office, your clients, close to somebody dealing with your client's office, they should tell their managers so they can be screened out of the procurement.
The brother's kind of an easier case. What about somebody who's got good friends at all the firms they're in?
Yeah. What about a judge? You know, procurement officer, deciding how to give these money is almost like being a judge on the third district court. You're a third district court judge. If everybody who appears before you is a close friend, maybe you're in the wrong job. Yeah. I mean, maybe one or two, you can say, I'm going to recuse myself from this case. But if you have to recuse yourself from every case, then you never sit out a case. Sooner or later, somebody's going to say, well, maybe we don't need your services as a judge.
But if
So-
you're in Farragut, maybe everybody in town is.
That's right. So what if you are in a small town in Utah, and you're in one of these special districts, can you socialize with them? Can you go to a church meeting, let's say, and they're all there? You know, yeah,
Or a bar meeting.
yeah. So
Yeah.
you're gonna have to use some discretion there, meeting at the bar, yeah. But if you
Not
can,
at the bar, oh.
I don't know what kind of bar you're at. Bottom line is use some discretion. If you feel like you're too close to somebody, you can't be independent, get somebody else involved. You know, you're right. Once you get into some of these very little type districts, it gets very difficult. Generally for the state, though, with our state agencies, this isn't the case. There's other people that can sit in and take care of it. I had all these provisions going through the procurement code. What you do need to know here is the Attorney General's office has certain things that they can do without the supervision of the Division of Purchasing. And that is retain outside counsel or procure litigation support services, including retaining an expert witness. I would say anything that's litigation support, like a court reporter. Division of Purchasing doesn't want to get involved in it. However, like even on our BCS case, where we're going after the college bowl system, and we were working on that RFP, we did involve the Division of Purchasing with it. Even in this case, let's say we didn't have to. Sometimes when you have a complex RFP, you do want to get these complex RFP experts involved and assist you, and they usually will help you. I saw a question.
I have a really quick question about hiring an expert witness. I'm going through that process right now, but I'm going through it with my agency, and we rarely hire experts, and it's really kind of a cumbersome process. And so I'm curious if, it looks like I could have done it myself, but would I then have to get the agency to pay for it? Because it's not the
You
agency.
could, and if we procured it under our AG rule, then you could hire an expert witness up to $100,000 as a small purchase. And then you just have to, as we'll go through later, if we have time, maximize competition. Meaning, just don't hire the same expert witness over and over again, every single case. Do some sort of rotational system or something, maybe the top 3 or whatever, but
But, I mean, if we already, we know who we want to hire, see, we don't want to go through the bidding process, because it's a highly specialized person, can we,
well, sometimes if it's a sole source, you can
Yes.
qualify under that. You have to be careful. Under the procurement codes, we have, one of the time to get to it today, if the sole source is over $50,000 in value. I think that's the amount in there. You have to put a notice on the website or a newspaper or somewhere, and somebody else can come out of the woodwork and say, hey, I can do that. It's not a sole source. So you better make sure it really is a sole source before you identify it as a sole source. An expert witness is a sole source. Offhand, I find it a little hard to believe, because usually cases have expert witnesses on both sides, and the idea that there can only be one out there, and they're just on one of the sides, that's going to be really rare. Maybe in your case it is that one of those rare things, but I'll tell you, it sounds suspicious offhand.
There's another reason why you don't want your agency to do it, and that is, if you do it, it's attorney work product. If your agency hires them, it's not. That's my understanding.
Yeah.
but then who pays for it though? Because I don't think.
You bill the agency.
Okay, you bill the
You
agency.
bill the agency, but you want, there's a difference between an agency retained expert and the attorney retained expert, as I see it. I'm open to argument.
Yeah, if you guys able to follow these changes on the slides. This is what I want to get to here at the end here, is just to let you know that we have an AG rule on hiring outside counsels and expert witnesses based on our statutory authority 67532. That this happened recently, but look at R 105-1. It's on the website. Please read that carefully, because that is just all about our Attorney General's office. And I don't, you don't need the definition of expert witness. You don't need the definition of, I think outside counsel should say is not inside counsel. And that should be the definition. Okay. RFPs, request for proposals, as opposed to invitation for bids. You know a little bit about the difference in that. Invitation for bids, basically I want to buy pencils, number 2 pencils. I may say, okay, who's got the cheapest number 2 pencil around? Okay, and I want to buy 10,000 of them, and I can specify it. Probably not going to do a request for proposal. But you want to hire an expert witness, certainly a firm, do a complex case. A request for proposal is where you want to go, unless it qualifies as a small purchase. Because a request for proposal allows you to weigh in price and other factors. An example, if you're going to get heart surgery, you don't call the hospitals and say, look, who's your cheapest heart surgeon that you have? Because I need heart surgery. You know, so assuming you're well insured, you might want one of the more expensive heart surgeons, since you might want to live after it. So request for proposals are for those complicated things. I want to get to something that's more valuable for you. It discusses the RFP process in here, the contents of the RFP, our small purchase process. This is important. Small purchase, outside counsel, expert witnesses, or other professional litigation support services under $100,000. That's a small purchase. We made it that way because we don't want to go through these expensive RFP processes every time you want to hire an expert witness. Sherry?
So that's how I got hired, because I'm under.
This ain't got hired in the office? Yes, you were a small purchase.
The $100,000 small purchase, you keep saying for the Attorney General's office, is that threshold amount apply across the board for all agencies?
Wow, that's an excellent question. I should be giving you a Skittles or something.
Yeah, okay.
Anybody can grab whatever they want up there. I'll leave it there. But now maybe I better not, because you're gonna have to score the presentation. And everybody will say, how come Alan's group, you know, he got all A's or whatever, you know, and then they'll find out you got the Skittles and things like that. So to get to your question, the good news is the Division of Purchasing just recently adopted a similar administrative rule for professional services, small purchases, with the same amount of $100,000 as the threshold. So most of your agencies that are under the Division of Purchasing rules will have the same $100,000 amount for professional services. UDOT, I believe, you have to double check that. I believe they may have $250,000 as their amount for small purchases. Because when you're dealing with $1 billion highway, $200,000 is, you really don't want to do an RFP for that on that highway project if it's related to that. But check the UDOT rule for that, because it might be as high as 250.
And it's even much more complicated than that.
Yeah. Notice if it's not, if it's a procurement item, in other words, you're not hiring like these professional litigation support services. If it's an item, and this could arguably be, we're having some debate about this, like a court reporter, maybe you need special software. That has a threshold of $50,000. And most of the time, you're not going to see that anyway. So these are fairly high limits for small purchases. We should be okay as an office in dealing with that. We talk about sole sources that can apply to our office. An important thing to know in our rule, which makes us different from most entities, is sometimes when we're hiring a law firm, or hiring an expert, or hiring an investigator, it's secret. I mean, you know, if we think somebody in Salt Lake or wherever, I should pick on a small town, right, is doing something really corrupt and we want to hire an investigator to do it, we don't want to put something in the newspaper saying that we think that on 3rd Avenue, somebody is doing X, Y, and Z, and so we're looking for an investigator to check out on this person. The investigator will be secretly working for our office. We put this in the newspaper, and it sort of defeats the purpose of, you know, trying to hire that sort of advertising. So there is an emergency section in the procurement code for emergency procurements. Our rules indicate that we do it on some emergency basis, not provide that public notice, but we're still supposed to have as much competition as possible while taking care of that emergency circumstance. This is really a tough area that has to be dealt with on a case-by-case basis. I mean, I suggest when these things happen that we have several minds get together before we just go ahead and do this. There's confidentiality requirements you know, procurement that relate to grandma. When you do your RFPs, people can submit and mark certain things as business confidential or trade secrets. Then you're supposed to honor that under certain processes. You need to know about that. Certain things get disclosed after an award, and certain things don't. That's in our rule. There's a whole section on contingency fee contracts, and we're running out of time on our rule. Please pay attention to this because the legislature in the statute wanted to have us in the rule, and some legislators looked at our rule to make sure we were complying with it. So we have to, our contingency fee contracts, we have certain requirements, and we have to have oversight, certain requirements where we have to share them with the President of the Senate and Speaker of the House. And that's it. That's all we really have time for. There's 100 slides I couldn't go through here, but they're on the website, and a lot of the documents on the website. You really were a great group. It's hard to do this with this many people and bring up the energy, I know. And it also wasn't a fun, glamorous topic, so I appreciate that you were willing to stick around for it, especially Jerry, who even had to go and still stuck around. So thank you very much. A great group of people.